Before we take our break, I want to interject one quick story here. I said before that I think there's some things that are worth repeating over and over again, and my favorite thing that I think is worth repeating over and over is that in any situation, every day of your professional career, you should ask yourself, do I have a client? Who is my client? And it just sounds so dumb, I know, but I'm going to give you an example. I take ethics calls from attorneys, and I have for many years. And I had a call from a very experienced domestic relations attorney. I think he's now retired. I didn't know him well, but I knew him. We'd spoken over the years. And I want to say he had an unblemished career. This is not a grievance story. But he called me one afternoon, and he starts to tell me about this domestic relations case that he had. He represented the wife, and it had gone on, and the decree has gone on. And I'm like, what are you asking me? This isn't going anywhere. He's not asking me a question. And I said, is this a problem regarding a bill? And he said, no, she's paid me about $110,000, and she probably owes me maybe she owes me $6. And I said, well, what's your question? And he said to me, well, she wants me to file this post decree. I'm not a DR attorney, so I don't know what it is, but she wants me to file this post decree thing, and I don't want to do it. And do I have to do it, Terry? And I said, well, do you still represent her? He said, well, I don't know. You see, thank you for laughing. I don't think that's a very good answer from an experienced attorney who's been paid $110,000. It's just, so it's not just the law students here that I'm picking on or the new lawyers. It's at all stages of your career. The other way that we see that question come up more commonly is older lawyer represents family business for 25 years, whatever it is. Grandpa who started the business moves to Florida. Now we got the dreaded second generation, and they're not getting along. And the lawyer, well, the lawyer's client was Grandpa for 25 years. What's going on now? Well, who's your client? Well, I don't know, but the kids aren't agreeing. And we've seen that a number of times. So I really think it's not a waste of time every day of your professional life, every time you walk into a hearing room, whatever you're doing. Just quickly, wait a minute, what am I doing here? Who do I represent? Because it can really explode on you. It's time for our break. Thank you all for your wonderful attention this morning. Thank you. Okay, our next subject is the important topic of setting fees and getting paid. And our speaker is Rich Setterberg.
Thank you, Terry. I wish this had been around 20 years ago when I did this. So Terry and Dimity, thank you very much for inviting me to talk and to talk to you all about fees and billing. First of all, I'm probably going to double back on a few things that everybody said because it just inspired some additional thoughts that I've had on what you all might want to do. Point number one, we all, best I can tell, made the biggest marketing mistake in the book. How would you reach us? I don't see my email address there, my telephone number. We should have been more attentive to that. So here's what you do. Pens and pencils ready? My website is setterberglaw.com. And if you go to that website, you'll find a contact me button, which will email me at rich@setterberglaw.com. That's how you reach me. The rest of you guys, you're on your own. Anybody in this room like to do their work on a Caribbean island, looking out over the water, doing your doing billable work that you actually get paid for? Anybody in the room? Well, I do. And I did. And I did that last month for an entire month. I did enough work to pay for the trip. That's one of the benefits that you can get if you work for yourself. Now, what do I mean by work for myself? Let me tell you a little bit about what I do. I worked for large firms in New York City and in Cincinnati for a while. Sat on the 4-year bubble. You know what the 4-year bubble is, right? Your partner comes in, he says, knock, knock. You say, who's there? And he says, not you anymore. So you have to go somewhere else. And eventually, in 1992, I said, oh my God, what am I going to do now? And so I decided to go out on my own. I would not change a thing ever since. I was a litigator for 15 years, working with the best and the brightest in New York City. All the litigators there strut sitting down. And when I finally got Cincinnati, things were a little more genteel, but I said, I just got to get out of this. I can't do this anymore. So I reinvented myself as a healthcare lawyer. So point number one for all of you who decided that you're going to be a trust and estates lawyer, a domestic relations lawyer, guess what? You might be wrong. So point is, don't be afraid to do something different if it's not working for you. I don't think any of us has said that yet today, but it is certainly possible that you'll get out there, you'll start doing what you're doing, you'll say, you know what, this doesn't race my motor. I've got to do something different. And I gave up 15 years of learning the rules and how to argue before an appellate panel and how to try cases and cross-examine witnesses, and I had to give that all up, right? No, you don't really give it up. You use those skills in whatever you do. So don't be afraid to change horses if that seems to make sense to you. The other way that I think I'm unique, at least in respect to some of the speakers we've heard today, is that I am a true solo practitioner in that you're looking at the Richard A. Setterberg Company. I have no paralegals, no secretaries, no associates. I'm it. And I work out of my house. I have a loft in my home. I have never practiced, ever since I went out on my own, I've never practiced elsewhere. So I no longer set my alarm, although I get up at 7 anyway. Toddle upstairs to my loft in my jammies, check my email, and start work. So if that has any appeal to you, that's something that you can do if you're in my circumstance. Of course, that leaves you without some of the luxuries of working with other lawyers. You don't have a chance to talk to other people. It's very difficult sometimes if you have a creative idea, you want to bounce off somebody, say, well, geez, how do I do that? So there are challenges to that line of work, but if I choose to work on a Saturday, I may. If I choose to not work on a Monday, Tuesday, or Wednesday and take advantage of cheap fares somewhere, I can do that. So having no one else to be responsible for it can be very, very liberating. And if anybody wants to talk to me about any of these ideas, please feel free to get in touch. I'm always glad to give people pointers and tips and so forth on how to manage that. The other benefit, the other thing that's happened, we talked a little bit about technology. You can do this. I promise you can do this. I've gone paperless. I don't have a shred of paper in my office. Now, some practices you can't do that. If you have wills or things like that and you need to keep actual, honest-to-goodness, real paper, you can do that. But I no longer have paper files at all. It goes into my scanner. It has OCR capability, so I can search it. I put it on my computer. I back it up, just like everybody should. And when I want to go look for it, all I've got to do is search my computer, and there it is. And I assure you, I get to it faster than those big stacks of paper that I used to have. So there's a competence dimension to that as well. So let's get back to the topic that I've been asked to talk about, that's setting fees and retainers. I guarantee you that the most exciting moment in my professional career once I went out in 1992 was when my first check came in. Yes, this is mine. With those of us who worked at firms, we never saw the stuff come in. The client would send this great big check to somebody. You never saw that. All you ever saw was a partnership draw or associate salary or whatever it is, but you never saw it. And really, it's just an amazingly fun feeling to say, this is mine. And if you're a solo, you're not working for anybody else, it's all yours. So obviously, you got to figure out what to do with it, how to manage it, and so forth. That's a topic for other people. But that's really a nice way to open with this. The Ohio rules say very little about fees. I mean, you can go to Rule 1.15. Tells you about 1.5. Sorry, tells you about they have to be reasonable, how to manage splitting fees among other lawyers and so forth. But it really doesn't tell you much about how you go about the process of deciding what to charge, how to bill it, how to paper it, and so forth. So that's where I'm going to spend my time today. But before we do that, I really need to touch on a subject that we haven't spoken a lot about today, and that's about conflicts checks. You know, we get a client calls in, Beth gave you everything you need to know about what your stomach ought to tell you about whether to take the client or not, and Lord knows I've had a number of those. I am very pleased and sad to tell you that I gave up a substantial earning opportunity because I did not want anything to do with this lawyer. And you just got to have the guts to do that because you'll sleep better at night, you'll have a lot more fun with your practice. So the question about whether you take the case or not will depend on a lot of things. Beth mentioned some, but one is a thorough and competent conflicts check. Now, of course, if you're brand new, just starting out, you may think that you have nothing to worry about, but if you have represented, if you've been out 4, 5, 6, 10 years, whatever, you've got a lot of former clients out there. And let me tell you, the rules, the set of rules in the Ohio rules, and they start at 1.7, 8, 9, 10, and then prospective clients rule 1.18, are among the most complicated, difficult to grasp rules in the entire code. And if you ever have a conflict problem or question, I would not recommend that you guess. I recommend that you go to the rules. My colleague in Kentucky, Pete Gullett, and I are doing a 1-hour session with the Kentucky Law Update. Any Kentucky lawyers in here? Okay, if any of you are going to the Kentucky Law Update sessions in Covington, I think it's in December, or wherever, you can get a lot more detail on this. But the short answer is you must have a system for determining whether you have or will have a conflict of interest. Because here's what happens with conflicts. You think you've got no problem, but you haven't done what? You haven't looked into the future. You haven't looked to see who might conflict. You haven't dug deep enough into the corporation to figure out that you've actually got a conflict, but you don't know it. And then after a certain amount of work, you've got to withdraw. You can't keep the client. So doing a competent conflicts check is an essential part of every client that walks in the door. All right, so let's assume you have no conflicts check. The client hasn't made you throw up. It's a question that you think you can handle competently, and you've decided you're going to go ahead and take this client. So then the question is, what sort of billing arrangement you come up with. And this billing discussion can and should begin, as Beth suggests, at your intake interview. Because if the client can't afford you, or the amount of money that you think it's going to cost to get him out of the soup is going to be too much, he's entitled to know that up front. So having that discussion early is a very important discussion to have. But you know what else it is? It's a marketing tool. All right. You all have heard that getting those people in the door is the real hard work. All right, now they're in the door. You think you can do it. The client is ready and willing to pay, and that's genuine. and you think you can help the client. Now it's time for you to close the deal. And to close the deal, you sometimes need to do all of the things that many of the speakers talked about today. Give them a sense that you care. Give them the sense that you either know the answer, or if you don't know the answer, you can find the answer. Give them a sense that you're committed to their problem and to the solution. And if you use that as a marketing tool, you may keep that person from spending a lot of time shopping. They'll say, I really have a good feeling about this guy. I'm going to take this lawyer. So use it as a marketing opportunity as well as a basis for talking about the things that are necessary to get the initial bit of information. By the way, on the conflicts check issue, don't forget that you should be taking only as much information as you need to complete your conflicts check. Because once that client walks in the door and starts spilling his guts, he becomes a former client. That's the way the rules treat it. And if you find that you have a conflict, then you got to run all the traps to figure out whether you can either take that client or have to give him up because he's given you too much information. So be careful in your intake interview to make sure that you don't fall afoul of that problem. Okay, so the types of billing arrangements. I like to talk about this not because the more traditional ones are obvious, but there's some that are not quite as obvious. There's the traditional hourly fee-for-service arrangement. Yeah, I charge $300 an hour. Here's how I bill, blah, blah, blah. That's easy enough to grasp. Everybody's pretty familiar with that. Those of you who do personal injury work also know that there are contingency arrangements, and they are also covered by the rules in Ohio. You've got to be careful about that, disclosing matters to the plaintiff contingent. But by the way, it doesn't always have to be a personal injury case. I'm familiar with a person who did appropriation cases. I said, I think this is worth $5 million. The government thinks it's worth $3 million. I'll take a certain percentage of everything I get over 3. Yeah, you can be creative. And this is particularly easy when you have your own firm. You don't have to get the approval of your executive committee. Guess who's the executive committee? Me. I get to choose. Not lightly, not quickly, and sometimes after a little bit of thought, but still, it's your decision. There are retainer arrangements. Those are sometimes variously defined, but sometimes they can be, I will do this, I want you to deposit $10,000 and we'll put it in a special trust account. We're going to hear about that next. And then you work against that amount. Sometimes it's a fixed fee arrangement. I'll do this whole thing for $500, that sort of thing. Make sure that you paper that the client understands what's included and what's not included. I started my practice actually with an idea that wasn't well received, well, not well received, it wasn't well understood at the time. And I like to call it project arrangements. And it's a lot like, a domestic relations or bankruptcy lawyer saying, I'll do this for X dollars. Except my X is a lot bigger. I am a healthcare lawyer. I represent doctors, hospitals, health insurance companies in a very small area of practice dealing with medical staff matters, credentialing, privileging, peer review. And sometimes hospitals will come to me and say, Rich, these are governed by a document in the hospital called the medical staff bylaws. And our bylaws are a mess. They haven't been redone in 15 years. They really need updating. Will you help me? So I said, yes. And here's what we'll do. I will do basically everything. And that will take you from draft through final approval by the Board of Trustees. And it'll cost you $60,000. And you'll pay me $5,000 a month for 6 months. And we'll be done. Well, people say, well, wait a second. I mean, how can you do that? And the answer is very carefully. When I first started doing that, I was concerned that I would lose my shirt, that I would, there are all sorts of problems. You figure, the client's going to call me every 10 minutes. Answer, sometimes they do. But you know how long that lasts? A month. Because once they gain confidence in you, they realize you've got it under control. You've set a timetable for drafts. You've set a timetable for what has to happen. They know the timetable. You stick to the timetable. They ask, the number of questions are less and less and less. So, I've never faced the situation where we interrupted things midstream and they've kind of paid me more than maybe my services were worth. You'll want to work that out if it happens, but it's never been a problem. In fact, one time I did a job, I finished it. There were unexpected developments within the medical staff. This doctor wanted one thing, and they said, oh, well, can we expand the project? Sure, no problem. By the time I was done, I'd say pretty close to break even if I figured it on an hourly basis. The client said, I think you've done more than what we agreed to in our fee agreement. I'd like you to send me a bill for whatever extra work you did. Anybody have that happen? Anybody volunteer to pay more? It happens, doesn't it, Nick? If you make the client happy enough, you know, they're not all sleazy out there. They're actually, some of them have consciences. And they realize that you've done a good job and they're willing to make up what you did. So that's the benefit of the project arrangement. Yes, the client could abuse it, but in my experience, they don't. Yes, you could abuse it, but I don't, because I'm what? I'm trying to make these guys happy. I want them to come back. I want them to tell me that I did a good job. Virtually all of my work comes via referral from other lawyers or other clients who said, hey, he did a good job. So that's a precious commodity. It's very easy to lose. So make sure that you work at that every minute of the day, no matter how you bill. So papering the file becomes very important for a number of reasons. First thing you're obviously going to want to do is an engagement letter. Now let me take the example of the engagement letter with my project assignment, because the project assignment has so many unique features that I tend to want to go into more detail than I often would with others, because I'm using this as a basis for our mutual understanding. And what else am I doing? I'm marketing. Again, still. I'm writing down, okay, here's the scope of our project. And then I will go through, here's how generally things ought to go. Here is the timetable that I think things will take. Could vary, but let's use these as our initial targets. Then I'll say, here are the difficulties that we might anticipate. Now, why is this good marketing? Because you've given the client the opportunity to see that you're engaged. You've been listening. You heard them say that Dr. So-and-so, who was the drafter of the original document, has a particular way of doing things, and he's going to give you some trouble. And so let them know that you understand that that's a thing that you're going to have to face, and ask and tell them what you propose to do about that. Make sure that guy's on the bylaws committee, right? So that he gets a voice in this new process. You know, and don't spend your entire time on this project trashing his work. Just say, look, we're standing on your shoulders. You know, you did a fine job, but it's 2014 and we can do better because things have changed, things have this, that, and the other thing. And then you say, okay, here's the fee, here's the payment schedule, and I typically also say something like, you know, we think this is going to take until March, but we all know things slip, so let's consider the project ending in May. But if it ends after May, we need to talk again, because there are probably some organic things that have caused it to get longer, and I reserve the right to charge an additional fee. That's never happened. Like I said this earlier one, they volunteered to pay more. So, and then you send a copy to them. They look at it. They may make changes. They may not. But what we've done is we've set expectations. Nobody is surprised. They know how much they're going to pay. Their accountants love it. You know, the accounting department says, you mean all we have to do is write a check for $10,000 every month? Yeah, that's all you got to do. It's not going to get higher. Nope, it's not going to get higher. If you're doing when I'm doing an hourly fee arrangement, a couple of points that I'd like to make. First of all, the client must be clear that you are not making any guarantees. You cannot promise a result. You cannot promise that things will go the way you have told them you hope they'll go, because in fact they don't often go that way. And I have language I love. I can't quote it verbatim, but the gist of it is judges and juries sometimes don't understand as well as we do what your legal rights, and they often get it wrong. And I can't guarantee that we will get a favorable verdict or whatever, but I can promise you that I will do my very best to represent your interests throughout our representation. Then the other thing I do at the end of an hourly fee arrangement is I have what's called a client bill of rights. Because another thing, and I think Beth mentioned, others may have too, people hate lawyers. And they hate lawyers even more when they've got to hire one and pay out of their own pockets. So it's sometimes useful to tell a client, look, there are things that I think you're entitled to. You're entitled to my zealous representation of your rights. Okay, yeah, that's really nice. What does that mean? Well, one thing it means is I will return every telephone call within 1 business day, usually sooner. And then keep that promise. Number one complaint that doesn't arise to an ethical issue is lawyers don't ever return calls. Don't make that mistake. Yes, their clients are going to pester you forever, but eventually they realize that you don't really have anything to add to what you've already said. Exceptions, of course, there are, but keep that rule. How often you bill, what increments you use, quarter hour, half hour, or a tenth of an hour, whatever it is. You all know you can have 3 2-minute telephone calls. Is that a quarter of an hour each time you pick up the phone? Well, not in my book. So I tend to aggregate things. I don't bill for every second. And of course, I also say no costs, no telephone charges, postage, fax, whatever we always used to charge 43 cents for. I haven't been doing for 20 years. The client appreciates it. There are typically no out-of-pocket costs anyway, so you just don't bother with it. And I mean, clients appreciate that you're not going to nickel-dime them to death if you say things like that. Very quickly, because I'm running out of time, rejection letters. If you decline representation, you must put that in writing. You must make sure the client gets it, and you must keep a copy so that you are clear about the fact that you are not his lawyer. Disengagement letters, we talked about that a little bit earlier. If you are done, tell the client you are done. This appears to conclude our representation, so I am closing my file. Those are my magic words. And if you ever need assistance again, please feel free to call on me. That does what? Starts the statute of limitations. Billing practices, I shouldn't have to say this to anybody. I used to do an hour-long thing on fees and billing, but I'll run through them really quickly. Number one, don't pad your time. It's so tempting as a private, single lawyer. Gee, nobody's going to know. People will know. Padding your expenses, go on a trip for a client, meals you didn't eat, tips you didn't give, that sort of stuff. Again, what is that? It's a federal crime. Why? Because you've either put it in the mail or you stuck it on an email and it's wire fraud or mail fraud. You can go to jail. And there are lawyers who have. Don't do it. Don't do other things on the client meter. It's easy to write down 8 hours research, but half of that time you went to lunch and you went to the coffee machine, you took a bathroom break on the phone with your wife and so forth. Don't do that. Don't bill your rate for the work of others. Webster Hubbell found that out the hard way, part of the Clinton administration, most ethical administration in the history of the nation. Just ask them. And you'll find that he wound up in deep legal trouble because he billed his paralegal work at his own rate. Don't do that. Keeping good records and writing it down when you are doing your own time records. Make sure that you keep a record. I had a partner once who, at the end of the month, would cloister himself in his office with his cron file and his telephone records and created what amounted to a work of fiction. Because you just can't say I did this. And generally, you're shorting yourself. But keep very good records of what you do by writing it down. And using an efficient billing system is also a part of it. A lot of people talked about time slips and other computerized methodologies. But for 20 years, I have used an Excel spreadsheet. I type the description, I type the number of hours, you know, the column multiplies it times my billing rate. I print it out. When I say print it out, I mean I use Adobe, you know, Dan was right. PDF, or Adobe Acrobat is the absolute wonder product of the legal profession. Print it out on a PDF, attach it to an email, and send it to the client, and you're done. So it doesn't have to be complicated. It should be complete, and that way you are not tempted to lie, not tempted to make things up. You do it honestly. And of course, there's one other thing that you'll do before you send out a bill. You're going to check it for reasonableness. You know, did you do a one-page letter and, you know, for some reason it winds up being 4 hours? Don't do that either. I think I'm done.
Thanks, Rich. Thanks
Thank
very
you.
much.